Hello, my name is Kevin Thompson, and I'm a member with Davis McGrath LLC here in Chicago. And I'd like to welcome you all to the Davis McGrath LLC IP webinar series for December 7th, 2011. Today we'll be talking about online works, copyright registration, and enforcement. We will be going for about 30 minutes, and I'd like to point people to our blog where the recording and slides will be posted at the address shown on your screen, blog.davismcgrath.com/webinars, and which you can also sign up for a webinar mailing list there. Our next webinar will be coming up on January 11th, 2012, again from 12 to 12:30, on using the Madrid Protocol for International Trademark Protection. So today we're going to be going for about 30 minutes, and this is sort of more an advanced view of copyrights. One of our prior webinars was on copyright basics, so if you'd like a more introductory look at that, you can go back to the blog and watch the recording there. Today we'll be talking mainly about registering copyrights in digital content, such as websites, Multimedia Works, so forth. And then we're going to talk a little bit about just what is copyright infringement, what are the damages and other consequences, and then how to deal with online infringements. We did talk about some of these issues again in the copyright basics, but we're going to try to go a little bit more advanced in this particular session. So at all points throughout the webinar, if you have questions, please feel free to post them. There is a place within the webinar where you can post them and hopefully get an answer. There will also be time at the end for questions as well. So the number one question, which is how do I register my works, that comes out through the Copyright Office. The Copyright Office, the website is copyright.gov, and there's a screenshot there. I'm going to show here on my screen that there's pages there where it's a little bit about copyright basics and frequently asked questions, and they also have over here down at the bottom an area where you can get circulars and brochures and forms. Although, to be perfectly honest, the easiest thing to use these days would be the electronic copyright registration system if you're interested in registering your own works. And it's certainly not as easy as, for example, the Trademark Office's online system, but it's not bad. And once you use it a few times, it becomes a fairly straightforward way of registering your works. Again, the website address is there, and as I mentioned, the form, circulars, and electronic filing are available. Registration covers for digital work the copyrightable content that is actually received in the Copyright Office and identified in the application as the subject of the claim. And it specifically excludes material that has been registered previously, and also published works are limited to the work as published on the date given. For example, if you register your website as of a particular date and you modify it after that date, only the work as registered on that particular date is protected. How do you submit an application? What do you submit with it? You need to submit a copy of the work and a fee, and we'll talk about both of those as we go forward here. The fees currently are $35 for an online registration, and if you still want to file on paper or if you absolutely have to because of the nature of what you're filing, $65 is the current fee for that. And I've also listed the place on the copyright website where the full chart of fees can be located. Now, the deposit materials vary differently on what it is that you're actually trying to register, and we'll talk about those as we go in a little bit more example. But the Copyright Office asks for what's called the best edition for published works. For example, if you have something that's published online and offline, for example, if you're trying to digital edition of a book that's also published on paper, the best edition for that would be the paper copy. And so that's what the Copyright Office wants. But if it's only sold online, then you can get away with submitting a digital copy. And there's a wide variety of formats that they accept, ranging from PDF to other formats as well. Now, published definitely means something a little different than you may think of in the normal publishing context. This definition of publication comes from before there were such things as online works. And so the Copyright Office leaves it in your discretion as to whether or not the work has been published. And I'll talk about this here, go through the definition. It's defined as the distribution of copies or phonorecords of a work to the public by sale or other transfer of ownership, or by rental, lease, or lending. So the mere offering to distribute copies or phonorecords to a group of persons for further distribution does constitute publication. However, I think this is the key sentence here for online works, is that a public performance or display of a work does not of itself constitute publication. So just because you have put it out there on the website, but if, for example, it may not be available for sale, such as a regular website or online work, you're not selling your website. And if you're trying to register the website itself, it may not technically be published in the copyright sense. If the work is published, you need to provide the date and nation of publication, but if it's unpublished, you leave those fields blank. And again, it is your decision, not the Copyright Office's, whether or not the work is actually published. And again, it matters primarily for the purposes of how many copies need to be submitted and so forth. And there's some other issues as well that come up with publication. So now we're going to get into talking about specifics of different kinds of online works. And websites are certainly a broad category, something that I strongly recommend that people consider doing. But again, it's not as straightforward as you may think, because a lot of it depends on the nature of the website and what it is that you're doing. And it should be noted that each update constitutes a new work. So if you publish to your website on a particular day and you register it and then you update it, that's considered a derivative work of the original registered work. And if you later registered only the works that in between, as part of a supplemental registration, will be protected by that additional registration. Now, a lot of websites publish information on a schedule, and this is where they start looking at what's part of a normal publication, like a serial or a newsletter. There is two different ways to do it. One, it would be a serial registration for weekly or less often updates. If it's more of a newsletter, it can be done more often than weekly updates. And again, deposit requirements vary depending on when that information is also published on paper, like if it's a paper newsletter that's also distributed online, or whether it's totally online. Again, if it's on paper, they want to copy the paper. In some cases, a frequently updated online work could constitute an automated database. And so if that's the case, you can register a group of updates to that database covering a 3-month period within that same calendar year in a single registration. There are a lot of online works, such as a blog, that depend on databases for the generation and updates of their content. For example, you may not realize if you use something like WordPress, everything is stored in a MySQL database. And I don't believe that's what the Copyright Office is meaning by this automated database. I think what they're looking for more here is a database, a true database of facts and figures, and not blog posts. So the next major category will be photographs. Again, that they are capable of registration regardless of whether or not they're digital photographs versus regular photographs. They can be registered individually using the Form VA, or if you're actually filing on paper, you'd use a VA continuation sheet if it's in a group. But again, the online forms can handle this now. It's a fairly straightforward process. The next one is actually a quite fun one. It's called categories of Multimedia Works, and this really means when you've got an online work where you have authorship in 2 or more different types of media, and so long as the ownership, etc., of it is the same, it can be filed as one application. So if the ownership is the same, and I believe the other requirement is that it be published together as part of one work. The deposit requirements depend on the media that's actually used. Now we're going to get into talking about copyright infringement here. Here's a work that I found online, actually used with permission. You know, somebody posted this, thought it was kind of cute. What is copyright infringement? It is action by someone who is not the owner that usurps or interferes with one or more of the owner's exclusive rights. And we talked about exclusive rights in the prior Copyright Basics webinar, but essentially, just in brief summary, these could be the right for publication, the right to distribute copies, the right to create derivative works, and so forth. The remedies for infringement range from injunctive relief to have impoundment or destruction of the goods. You can get compensatory damages and profits. You can get costs and attorney's fees. And again, costs and attorney's fees would depend on whether or not you actually had a registration in place before the infringement occurred. And the same thing with statutory damages. If it's eligible for statutory damages, the normal range between $750 to $30,000. And in a case where you're able to prove willful infringement, damages can up to $150,000 per work. However, if you're able to convince the judge that what you've done is actually innocent infringement, that can lower the damages down to $200. Now, the defenses to infringement are definitely varied and are certainly not what lay people generally expect when it comes to infringement. You know, they think if they did it innocently, that's a defense, and it's not. As we talked just on the prior slide, innocent infringement is a way of reducing damages, but it's by itself it's not a defense. And fair use is something that we'll talk about in a little more detail in a second, but it's a defense to infringement. So if somebody doesn't buy your fair use defense, you're definitely liable for what occurred. So another word would be parody, trying to argue that the copyright itself is invalid. Estoppel is an equitable defense based on the factual situation set forth there. One would be misuse or unclean hands. So would be someone like using a registration that they're not supposed to be using, or using it in improper fashion could be done there. It used to be a defense of improper notice, but notice is no longer a requirement, so that's more of an older requirement. And the other thing to note is that there is a 3-year statute of limitations for copyright infringement actions, but there's also an equitable doctrine called laches that may apply. Laches is an equitable defense. Let's say you put somebody on notice, you send them a cease and desist letter, but you never do anything about it after that, and you don't actually get around to bothering to sue them for 6-7 years. Then laches will definitely apply. Like if they relied on your non-enforcement to their detriment after you put them on notice, laches can certainly come up to rear its head and bar your claim. If that's assuming that the statute of limitations itself hadn't run. Fair use is a 4-factor test. There's a great Supreme Court case that came out, I believe, in the late 80s, early 90s. The Two Live Crew case, in which it's certainly worthy of reading. What the court looks at is the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion used, and the effective use on the market for the copyrighted work. And again, as I noted before, it's important to note that fair use is a defense to infringement, but if the court does, or the trier of fact doesn't agree that it is a fair use, you're still on the hook for the infringement. Now, just a little bit of general advice without getting into specifics here, or without offering specific legal advice. But when you're facing, you're trying to use third-party content on your website, one thing to try to do is to try to track down who the owner actually is, and making sure that you have permission for that use. There's a copyright database that's on the website that may help you track down who the owner is for particular works. And it's also important to note that not all works require permission. For example, if the work is published under a Creative Commons license, the work may be available for use provided that you comply with the license terms, such as providing attribution to the author, or distributing the resulting work according to the same license. If you're interested in Creative Commons, creativecommons.org is a great website. Now we're going to turn into our last major topic, which is dealing with online infringements. And certainly the Digital Millennium Copyright Act, which is now part of our Standard Copyright Act, is certainly a popular topic, but it's by no means the only way of dealing with online infringements. Not all works are capable, or not all websites are subscribe to the DMCA system. It's mainly used for websites in which you're posting third-party content. If somebody is directly publishing, it's certainly worthwhile to just send a notice, but this particular provision of the Act is mainly designed for the more like publishing type of operations. It's certainly a cease and desist letter would be a good way of providing notice, and to put people a notice of your claims. So a DMCA takedown notice is not necessarily required. And so for here, we're going to briefly go through what is the DMCA, what is a notice, what is the proper notice format, who should be notified, what are the steps, and how long does it take, and what should I do if I don't like the result that I get. The DMCA is part of the Copyright Act now. It's Section 512, in that it provides a safe harbor from liability for an online service provider from hosting infringing content if it complies with the takedown notice that's provided from the owner. And in order to be eligible for this safe harbor, the online service provider is required to designate an agent for service of these notices. And so it's important if you are an operator of these websites to actually make sure you do register, because otherwise, if you don't register with the Copyright Office and pay the fee that's required, you're not going to be eligible for using this particular section. Somebody could still sue you for infringement, even if you otherwise, do comply with the takedown notice, just because you didn't register. And to qualify, the service provider must not have actual knowledge of the infringement, no direct financial benefit, and he must act quickly to remove the content once there is notice. A DMCA notice should have the physical or electronic signature of a person who is authorized to act on behalf of the owner. So that could be a lawyer. It could be somebody who's like a paralegal who's authorized to send these notices as well. It has to have an identification of the copyrighted work and an identification of the material claimed to be infringing. Not just a mere general notice, but it should have, like for example, if it's provided information is at a particular URL, you should provide that URL to put people on notice of where it's actually, the information can exactly be found. You should provide contact information, and it's important that you also have a statement that the party has a good faith belief that the use is not authorized by the owner and that the notice is accurate. The judge generally, the procedure requires notice given to the online service provider. The provider takes the material down and notifies the user who uploads the material. If material is taken down wrongly, the user can provide a counter notice. A counter notice is similar to a regular notice, plus requires there to be a statement consenting to jurisdiction in federal court, and within 10 to 14 days, if no suit is filed, after receiving that notification, within 10 to 14 days, if the person providing the original notice doesn't file suit in court, the material should be put back up. So it does take some time to go through the whole process. Now, why would somebody submit such a counter notice? Fair use, commentary, perhaps the person who's providing the notice is not the actual owner or agent, or what happens a lot is misidentification. There are some online service providers who receive automated takedown notices from content providers such as those within the recording industry and so forth, the things that match their automated parameters, but may not actually be the work that's alleged to be infringed. And so there is a lot of misidentification. The people providing these automated notices will try to claim that what they're doing is misidentification. Well, they're doing their best is what they'll try to claim, and the problem is that they themselves could be liable for submitting a false notice. So I certainly think I've covered these topics. Again, a little more in depth than what we did last time in the Copyright Basics. So at this point, if anybody has questions, now would be a good time to do so. Again, you can use the the form there as part of the webcast to submit your questions. Well, doesn't seem to be any yet. If you do have any later, please feel free to give me a call or send me an email. I'd be happy to answer them. Thank you all for coming. And again, our next webinar will be coming up in January. I believe I had it on the earlier slide. I believe it's coming up on the 11th, and we'll be talking about using the Madrid Protocol for international trademark applications. Thank you so much for attending.